Hello, my name is Joel Hayes. I'm the senior attorney at Bridge to Justice in Boulder, Colorado. I'm here to talk to you today about eviction notices and court forms you may receive as a tenant in Colorado. I should tell you this is only legal information, not legal advice, and you should consult with an attorney in any legal matter. Also, the law can change at any time. And finally, I'm going to use landlord and tenant in the singular form, but obviously there can be multiple landlords or tenants involved in an eviction. The first form I want to talk to you about is the notice to quit. The notice to quit advises the tenant that the landlord believes that the tenancy will terminate on a specific date. In the case of a month-to-month tenancy, either party can terminate the lease with a written notice given at least 21 days prior to the end of the monthly period. And most of the time, that's at the end of the month. In the case of a repeated breach of a lease by a tenant or a substantial breach of the lease by a tenant, the landlord can terminate the lease with only 3 days advance notice to quit. Another form that may be received before an eviction is filed is the demand for compliance or possession. This notifies the tenant that they have breached the lease and that they have a specific amount of time, generally 10 days, to cure that breach. Usually this is for non-payment of rent, but it can be for misbehavior of a tenant or guest or other breach of the lease. The failure to cure this breach can result in an eviction being filed by the landlord after the cure period expires. A notice to quit or demand for compliance or possession is usually the first formal step of an eviction. They serve to notify a tenant that the landlord is considering filing an eviction. Either form must be in writing and posted and either personally served on a tenant or other resident 15 years of age or older, or if that's not possible, posted in a conspicuous place. These titles of these forms are sometimes incorrect or used interchangeably, particularly by unrepresented landlords. And some landlords are required to give longer periods of notice under federal law, including some HUD recipients. The next form I need to talk to you about is the summons. This is a notice of a court deadline or a hearing date. The summons must state where and when the hearing is and what the tenant has to do in order to contest the eviction. In Boulder County, the tenant must appear in court and file an answer on a Friday, either in Boulder or Longmont, as stated in the summons. In Boulder, the court hearings are generally on Friday mornings at 8:30 or 9. In Longmont, the court hearings are generally at 10 a.m. The complaint states why the landlord is entitled to possession of the residency and any money damages that are claimed. It's supposed to give the legal and factual basis for the landlord's claims, but courts allow landlords to rely on the notice to quit or demand for compliance or possession in order to explain this. This has resulted in form complaints that simply list all possible bases that the landlord can rely on, making the complaint largely ineffective to determine the landlord's claims. Both the summons and the complaint start with a case caption that states where the court is and names the plaintiff and landlord. This is usually in a big box that covers about half of the first page. Other pleadings filed with the court should generally have the same caption to help the court organize the files. Both these forms must be in writing and served personally on the defendant or posted in a conspicuous place and mailed to the defendant if personal service is not possible. Service has to occur at least 7 days prior to the first hearing. The courts require some additional information to be attached to the complaint, including contact information for mediation and legal services programs that might help the tenants resolve or defend the eviction. It's important to read all the information that's served and to reach out for help right away. It's also important to appear in court and be prepared to negotiate, pay what's due, and/or file an answer to the eviction at the hearing. Again, this is only legal information. You should always consult an attorney if at all possible. Thank you and good luck.